Earlier, I caught up with the Industrial Relations Minister Christian Porter, who revealed exclusively to Sky News the new criminal offence details for wage theft that will form part of the IR reforms. Attorney General and Minister for Industrial Relations Christian Porter, thanks so much for your time. We can reveal this afternoon some very tough compliance measures on business when it comes to underpaying staff. This is part of your IR reform package. Can you talk us through it?
Yeah, that's right. And during our working group process, we started with some positions and concepts which we put to employers and unions. And this legislation will create for the first time ever a criminal offence of wage theft. I wouldn't say that the business groups were necessarily enthusiastic about that concept or this part of the legislation, but we considered with the raft of underpayments and the scale of some of them that a much clearer message needed to be sent. So for the first time ever, there will be a criminal offence of wage theft, which will carry a maximum penalty of 4 years imprisonment. And at the same time, we're increasing most of the civil penalties where it's not a criminal offence by about 50%, but also very importantly, introducing an alternative monetary penalty, which is measured against the benefit obtained. So if you like, the scale of the underpayment. So if it's not a criminal offence, which requires dishonesty and intention and large systemic underpayments, which constitute wage theft, it could still be a civil penalty which is very large, where the civil penalty now can be a measurement of the actual scale of the underpayment. And indeed, that might be either 2 times the scale of the underpayment or 3 times the scale of the underpayment, effectively as a fine. So you'll gather, Kieran, based on some of the underpayments we've seen, that could be a very large fine indeed.
It could be, and for the most egregious cases, criminal penalties, as you touched on there. There'd been some discussion about 10-year sentences. Why have you gone for 4 years maximum instead of 10?
Well, overwhelmingly, there was a view amongst the business groups that there shouldn't be a criminal offence of wage theft at all. We, as a government, stood our ground that we considered that it was appropriate, considering that the message clearly hadn't gotten through. We didn't consider to many large businesses that payroll was absolutely essential to their business and people just should not be underpaid. The criminal offence of wage theft is different from an inadvertent underpayment. Even if the inadvertent underpayment is serious, a criminal offence is something different again. That's a next level where you've got systemic, large, repeated underpayments, and there was dishonesty, which involved some intention on the part of the person who was underpaying. That is a very big step. We had started the discussion around a 10-year penalty. As I say, there was very little enthusiasm for the offence at all. In the end, we thought that at this point, given this is so new and such a significant departure from the law as it has previously existed, that a 4-year potential maximum penalty of imprisonment was the appropriate one. It can be also the case that for individuals there can be a fine of up to $1.1 million, or for corporations a fine of up to $5.5 million in addition to that 4-year penalty. It's also notable that if someone's convicted of that offence of wage theft, they're automatically disqualified from being a company director. So this is a very, very serious response. And not every issue that we took into the working groups is going to be completely loved in the outcome by either business or by the unions, but we've constantly tried to strike a middle ground here.
Minister, are there any examples that you can give us of practical examples that we've seen that would meet that threshold of criminal penalties?
Well, I can't. We haven't done the process, which only really, Kieran, a court can do, of applying a new offence against old circumstances. But I would probably say that the most egregious and blameworthy example of the underpaying scenario was probably what occurred in 7-Eleven. There have been a number of underpayments, which even ones that have been large have been genuine mistakes. And particularly with small business, there are genuine mistakes. But this criminal offence is meant to capture that type of underpayment, which is both large, systemic, it occurs in a patterned way over a period of time, and there's a mental element of dishonesty, which involves some level of intention to underpay. And the reason why this is so important is not just because we want workers to be paid properly, I mean, obviously we do, but for the overwhelming majority of businesses that do the right thing and pay their people properly, they get undercut by any competitor who doesn't pay their people properly. either by inadvertence or, more seriously, if they intend to do that, to give themselves a competitive advantage. So it's a very significant development in the law. Both the civil penalties, the criminal penalty, for the first time ever being effectively able to fine people with reference to the amount of the underpayment. We think that this is probably what's needed to get on top of this problem that we've seen emerge in the last couple of years.
You've released some details today on the casual worker component. Basically, it seems, trying to give certainty for business by giving a clarity around the definition of what meets casual work, but also for the worker themselves, someone who's been on set shifts on casual pay for, say, 12 months, they can move more easily to part-time or full-time work. The unions, though, and Labor have been critical here. They say there aren't enough safeguards for the worker to transition. Do you hear what they're saying on that?
Well, just like the business groups will be critical of us for having a criminal penalty for wage theft, no doubt there'll be some divergence of views as to how we've tried to fix what is a terrible mess in the economy with respect to what is or is not casual employment. And the context for your listeners is there was a very important decision of the Federal Court on 20 May 2020, and after that decision was made, it is very unfortunately the case in the Australian economy at the moment that prior to that date of 20 May 2020, no one really knows whether or not someone was employed as a casual or as a permanent. After that date, we still don't know whether or not people are being employed as casuals or permanents. Prior to that date, there's massive confusion as to whether or not you need to be paying the 25% casual loading for things like sick leave, or whether or not you need to be paying sick leave, or whether or not, in some circumstances, there could be claims in the courts for both those payments, which has been calculated as a liability up potentially to $39 billion. And all of this goes back to the fact that the Fair Work Act, when it was created by a previous Labor government, never included a definition of casual employment. So that just has to happen and the mess has to be sorted out. We've taken two principles to trying to sort out that problem. One, certainty, and two is choice. We want to make it absolutely clear when someone's been engaged as a casual or alternatively as a permanent part-time or full-time employee. And after they've been in that role for a year with 6 months regular hours, we want to make sure that they've got the choice, the genuine choice, to transfer from casual, if they want, to permanent part-time or permanent full-time. And the mechanism there is that we as a government are actually going to require business to offer that right to their employees who meet this 6-month regular hours criteria. Now, that's the first time that would have occurred in this type of way. It's a very, very strong right that would exist for people to convert, if they wanted to, from casual to permanent employment. And the protections around that are the same protections that exist in some of the existing casual conversion clauses. At first instance, that's a matter for discussion between the employer and employee. Then it can be arbitrated if there's consent. And of course, there's always disputes that can be determined in other ways. But it is a very, very strong way in which people, if they want, can convert from casual employment to permanent employment. And we think that's the best way to fix a problem. Certainty, making sure everyone knows how they're employed, and then choice. And some people may prefer, even if they do work fairly regular hours, to receive their 25% loading and not convert, and that will be a matter for them.
Have you got a sense of how many jobs might be created here? Because it's clear the government's view is that this confusion around casual work has been a handbrake on businesses putting people on.
It has been very difficult to quantify, but there is no doubt in 150 hours of consultation with businesses and with unions that there is real confusion out there, which is putting a handbrake on the very difficult decision sometimes for employers to actually create a new position and employ someone. There is a lot of confusion about how they actually employ someone as a casual, if that's what they, the owner, wants, and if that's what they, the employee, wants, and then how to pay them. And, to get some idea of the scale of this problem, the first $800,000 that were lost in COVID, 500,000 of them were casual positions. So trying to recover from COVID means trying to make sure that there are more offers to more people for more jobs everywhere, casual, permanent part-time, permanent full-time, But clearly we want to make sure that it is a growing part of the economy. And for many, many years, casual employment levels in the Australian economy have been very, very steady. We just want to make sure that businesses are confident to offer casual employment to people, which is a very important type of employment, that people can go into those positions knowing exactly how they should be paid and knowing that if they work for a period of time regularly, they've got a strong right to convert, if that's what they want, to become a permanent part-time or full-time employee.
Minister, the demerger bill that the government's introducing, this is basically being called the Setka bill because it's targeting the CFMEU, particularly the militant side of things. Are you confident of getting Labor support to get the union demerger bill through Parliament this week before Christmas?
I can't see why Labor wouldn't support it, and the bill simply institutes a pretty basic, fair and reasonable principle of freedom of association, that if you are part of a group of people in a union who represent a sector like mining or manufacturing, say for instance in the CFMEU, and you don't think that the union management and overall the union behaviour is in the best interest of your members, then you can vote to leave and you can set up your own union. And the economic benefit for Australia could potentially be very large, because we've seen that mining has been a saving industry during COVID, one of the few industries that actually managed to grow during COVID and keep employing people. So imagine a mining union which deals essentially and only with miners, which is managed and populated by decent, hard-working unionists who are representing the best interests of their members, who have good relationships with mining companies and can work cooperatively. And then you compare that to the sort of behaviour we've seen on Victorian construction sites. Having a specialist mining union behaving well and dealing well with mining companies can be a massive economic uplift for Australia. And bottom line is that if miners or any other part of the CFMEU are dissatisfied with the way in which the CFMEU is being run, and there's a lot of good reasons that you might think that they would be dissatisfied, they should be allowed to get out and go start their own union by ballot, democratically, fairly and reasonably and according to a process. But at the moment, the way the Act was drafted, once you're in, you're locked in forever, no matter how bad the management of your union might become. And we just think that that's wrong in principle. So this is good for the Australian economy. It certainly represents an important principle of freedom of association. And what possible reason could there be for not supporting this, particularly when many people inside the union movement want this, because it allows them the choice to leave a union if they think that union's behaving badly and not representing the best interests of their members.
And the Ensuring Integrity Bill obviously failed in the Parliament. Is this a roundabout way to try and achieve that accountability? You've had a fair bit to do with union leaders the last few months. Is this a way that you've worked, in conjunction with them to attain a bit of accountability where it's needed most in that space?
Well, I think that this will have the longer-term effect of enhancing accountability in the union movement. It'll have the short-term effect of potentially creating a union that works well with employers in one of the key industries that we're going to rely on in Australia to get us out of the COVID recession. But, I guess, Kieran, after months of working with employers and with the unions, you do learn a bit. And one of the things that I've learned is, like any organisation, people inside organisations often think and behave differently, and there's no absolute unanimities of views or behaviour. And inside the CFMEU, there's been a group of people who've behaved very, very badly and who've affected the construction industry in a very negative way and hurt job growth. And there's other people in that union who are sick of it and who want a better, more cooperative relationship with employers in the mining industry, who want to represent miners in Australia, whether they're in Western Australia or Queensland, better than they're being represented at the moment. So why wouldn't we give them that chance and opportunity to do better for their members, do better for job growth, do better for the Australian economy? It is a simple principle of freedom of association and the choice to either stay in a mega union or get out and start a union of your own, which is more specialised and which has a greater chance of escaping bad behaviour and doing better for your own members.
And before you go, 4 weeks ago, the Four Corners ran a program focusing in part on you. You rejected the claims categorically and described the report as defamatory. At the time, you said you'd look at your legal options. Where is that at? Will you take legal action?
Well, I'm still having a good think about that, and I do reject absolutely the assertions that were made on that show. I don't want to get distracted from this type of work, so I want to have a bit of a think about that as we manage to bed down some of these important economic legislative changes. I'm also going to wait and see what they do by way of response to the Minister's letter, which I think put in it a whole range of pretty important questions that deserve a response. So I'll have a bit of a cold, hard think about that over the coming weeks.
So a genuine look at it. It's not one of those lines you say in response to a controversy at the time. You're genuinely looking at that?
Yeah, I mean, like any good lawyer, Kieran, when I have a moment to have a little bit of quiet time to actually have a sober look at it all, and particularly the ABC responses to the Minister's letter, I'll have a look at it.
Attorney General and Minister for Industrial Relations, Christian Porter, thank you. Appreciate it.